for it. The proof is in. I have detectives sitting in all the time on closing argument.
Detectives were in there. What's the problem with that?
It's not that they're sitting in there first, they've all been sitting in, but just not 10 feet from the jury.
Well, but they're not testifying or anything.
The jury knows their presence there.
Well, so is everybody else in here. I note your objection for the record, all right? Bring them in. Shall they come?
Yeah.
All right. And if you're not finished by lunchtime, you will be allowed to finish after the lunch break, okay?
Okay, thank you.
All rise.
All right, please be seated. All right. Perez?
Good morning to each of you. I know this has been an experience for some of you who've never been involved in a criminal trial, and I want to thank you for being part of the process. I think it's very special that we can participate in something like this, that you all took your time away from where you live and dedicated yourself to this process, and that's very special and very meaningful. I know Mr. Reagan and Mr. Boland both appreciate that, as well as Mr. Vandenburg. Your attention span was just awesome, and I'm sure when I review the facts of the case, the way we see the facts, your memories will come forward and you'll see what this case is about. You just heard from the government their first opening argument, and I say first is because they'll be allowed to make a second argument. Unfortunately, the defense will not be allowed to stand up and say anything. So what we say right now, this is our final opportunity to speak to you. Please keep in mind, when Mr. Thurman gets up for the government and gives the second closing for the government, he's going to attempt to refute, rebuke, whatever it may be, whatever I say. So please, hear what I say, because this is, again, Mr. Vandenberg's sole opportunity to explain the facts and the details to each one of you. The case had some emotional ties. And this is one of those cases that you're like, wow, just wow. I've been doing this a long time. I don't look that way, but I've been doing it close to 26 years. And it's an emotional case. It's a difficult case. There's a lot of law. The law is very difficult in this case. It's not something that you can just breeze over, because there's a lot of little issues that are contained in the law. There's no winners here. No winners. Not from this side, not from that side. And that's what makes this case so difficult. There's none. There's none. But because there's none, you can't punish someone. You can't find someone guilty when the facts do not indicate that. When the government has not produced their facts beyond a reasonable doubt. Now, I understand they have their side. And I understand they tell you what they want to tell you, what they believe happened on this witness stand. But if you were here, and I know you all were, and I know you all were paying attention, you know there's more facts than they presented to you on their first closing statement. And they're going to get up and tell you exactly, if I tell you this, they're going to tell you that. And that's why, again, don't close your minds out. Hear me and understand the facts, especially when Mr. Thurman gets up. Not too long ago, I used to teach a trial class. And the interesting part was when I would talk to my students, was you have to understand the law. And I told you a few minutes ago that how difficult the law is in this case. It's not a drunk driving case. It's not a car accident case. It's just a civil case. It's a criminal case. This is a very, very serious case. Just right below murder. And the law, as I was telling my students, is you need to understand it, because if you don't understand it, how can you explain it to the triers of fact, which are the 13 of you? You're the triers of fact. You decide this case, not me, not the government, you. You heard the witnesses. You decide their credibility. You look at how they testified, whether they changed evidence, whether they gave faulty evidence, whether they didn't pick a piece of paper up, didn't document it. You decide that. There's a jury instruction that said it's all you. That is your job. That is your job. I can just tell you what I saw, what I think came out of this, but I can't tell you any more than that. And you decide whether I'm right, whether they're right. And that's your decision. The state government presented yesterday, when Mr. Moore read you the election of offenses. It's a 2-page document, but that's what they read to you. You have that in evidence. Count 1, count 2, count 3, count 4, and it goes on to count 7. There's no count 8 on that election of offenses. And what you don't see in that is Mr. Brandon Vandenburg's name. Count 1 is Brandon Banks. Count 2 is Cory Batey. Count 3 is Cory Lamont Batey. Count 4 is Cory Lamont Batey. Count 5 is Cory Lamont Batey. Count 6 is Brandon Banks. Count 7 is Cory Lamont Batey. And you wonder why? It's because they are not charging him with these counts of doing these things. They are trying to hold him and saying he is criminally responsible for these two individuals. They're holding someone else responsible for someone else's conduct and acts. So you have actually multiple issues to decide on this, and this is where it gets complicated. Because in order to hold, and count 5's up there on the top, so I'll just tell you, in order to hold Mr. Vandenburg liable or find him guilty for Cory Lamont Batey for what he did to the alleged victim in this matter, you first have to find that Cory Lamont Batey did this act. Not including Mr. Vandenburg. Mr. Vandenburg is out of this picture right here. You have to find Cory Lamont Batey did count 5 to the alleged victim. That's your first analysis. And what the state wanted you to do, and I have a list of evidence I'll go through, but I'm just going to talk to you about the law a little bit and interject a little bit of my opinion. With the state, with Ms. Norman, when she was up here speaking with you, what she wanted you to understand was she showed you these pictures. And she showed you the pictures from inside the dorm. And Detective Gish, who was seated in this witness stand, and you were going to all evaluate his credibility, he was saying how he pulled things from computers and hooked things up and pulled things out. And what the state did is they had him say, well, what's this represent or what's this represent? And if you recall, it's all appear. It appears he did this, it appears he did that. Because there's no pictures showing an act actually happening. The state will probably tell you, well, you can infer something, but they have to remember each element, prove beyond a reasonable doubt. You may think in your heart, this is wrong. Just the pictures are disgusting. No one should have to go through that. But they have to prove every element beyond a reasonable doubt. That's the law. You all took the oath that you would follow the law. I asked you, Mr. Bolin asked you, Mr. Reagan asked you during the jury selection whether you would follow the law, and you all said you would. So, in order to get to the second step, you have to evaluate the evidence. You have to evaluate the witnesses, which are evidence, if they testified, and conclude that Cory Lamont Batey did count 5 beyond a reasonable doubt. No, presentation to you. Proof beyond a reasonable doubt. Go to the second page. Go to the next page after that, please. A verdict of not guilty includes all the following, because a lot in this case, and I did this with the help of Mr. Vandenburg's team members, because the case was so difficult. This is an emotional case. There's no winners in this case at all. But a lot of times jurors have an inkling that this is just not right. And they forget about the state's burden, the government's burden to prove each element beyond a reasonable doubt. And it's the inkling to want to convict, find someone guilty, even though the proof isn't there. So when you're deliberating, when this case is to you and you're in the back room and you're sitting there and you're going over the evidence, remember these things. Probably guilty, that means not guilty. Falls a little short. All these things lead to not guilty. And this is what proof beyond reasonable doubt is. And here's a little chart. The abiding conviction that all the elements, not just one element, but all the elements in your analysis of first Cory Batey or Brandon Banks, depending on what charge you're on, must prove an abiding conviction. Then you can move on to Mr. Vandenburg. So I show this so you have an understanding when I talk about the facts of the case. The factual evidence up there that I believe is important to you. Now I'm not telling you what you should feel that's important to you. I'm just explaining to you what I think is important, should be important to you, what's important to me. And as we discussed a little bit earlier about elements, reasonable doubt, I'm going to interject Ms. Norman's closing to you. She talked about intoxication. And she made a statement to you which offended me because I don't think it was appropriate. And I stood up and objected.
Right. Yeah, stay away from that.
Okay. Right. But it was about intoxication, how everyone would use the defense, trying to minimize the defense. In a drunk driving case, there is no intoxication defense. There's none. This is not a drunk driving case. And I explained that earlier in jury selection. Intoxication is a defense to this case. You may not like it, but it's the law. And you all swore to all of us to follow the law. And where is it a defense to? I think that's important. Because do you just say, a person's intoxicated and therefore he's guilty of this or not guilty of this. No. It applies to the elements of intent, of knowing something. Intoxication has the ability to make you not understand things. Hence, Joey Quizno, who was Mr. Vandenburg's longtime friend, drove him out to Nashville to Vanderbilt University. In one phone call, he said he was speaking gibberish. In another phone call, he said he didn't know what he was doing, but I know what he was doing. I told him to get out of there. That's evidence. That's evidence of intoxication. That's evidence of not understanding and knowing where your surroundings are. The awareness that Miss Norman talked about. I'm aware of this, I'm aware of that. There was no questions asked of Miss Quizno, was he aware? The state had every opportunity. That was their witness. That was their witness. Mr. Quizno told you his opinion of his longtime friend. And what's important now, they're no longer friends. He doesn't like Mr. Vandenburg. So what could he do? Tell him, I was lying. He knew what he was doing. No. He said he did not know what he was doing. I understood, meaning Mr. Quinzio understood, but not Mr. Vandenburg. Drunkest I've ever seen him, or heard him. So the knowingly, Mr. Vandenburg has to knowingly, beyond reasonable doubt, understand what Mr. Cory Batey was doing. He has to appreciate what Mr. Cory Batey was doing. Intoxication, what Mr. Quinzio talked about, what he testified to you about, would be that defense to that element. We're not saying because Mr. Vandenburg was intoxicated beyond he's ever been because of anything else, these bad acts did not happen to the alleged victim. We are not saying that. Mr. Batey will have to meet his maker if you find that's what he did. What we're saying is Mr. Vandenburg did not appreciate what Mr. Batey was doing. Ms. Norman's closing to you. 2 minutes into something. Quick. So that is my law school education for you all. About the elements and about the fact, about how the law applies. Because again, intoxication is a defense to knowingly and intentional conduct. If you have intent, you have to compare it with the evidence of intoxication. It's not a drunk driving case. It's not walking in public intoxicated. It's a defense that's provided by the law. It's a defense that Mr. Vandenburg has because people have said he was intoxicated. He was drinking. Some of you don't drink. Some of you drink socially. And it's hard to comprehend and understand, but it's a defense, and we have evidence of that defense. So, let's look at the evidence here. We have Detective Gish, and there's some issues here. The government has to provide all their evidence and to us, reliable evidence, so that we can defend our clients. What did Detective Gish say on the stand that I feel is important? Said that Brandon Vandenburg tried to delete the software. But yet, when he searched for the deletion software, he never found it on Mr. Quizno's computer. Mr. Norman talked about that. He went over there in California and deleted everything, and Mr. Gish said on the stand, I didn't find any software inside Mr. Quizno's computer which would confirm that Mr. Vandenburg tried to delete evidence. Said that Mr. Brandon Vandenburg destroyed an iPhone 4S. I stood right here and I said, in the middle of counsel, I said, what did you find? He said, an iPhone 4. And I said, well, isn't that the same 4? No, it was an iPhone 4S. And then when Mr. Quizno, we took him out of turn, took the stand, I said, what phone did you allegedly have destroyed? He said it was an iPhone 4. An iPhone 4. He said he never owned an iPhone 4S. Never owned one. Those are the credibility things you look for in witnesses, ladies and gentlemen. That's what you look for if you want to believe someone or not believe someone. These are facts that were stated up by a witness up there, and you can review their testimony. This young lady here, I know it'll be painstaking, but you can hear their testimony right back. He said that Mr. Vandenburg searched on his phone. Can't police find deleted videos on his Samsung phone? That's what he showed you, that on his phone when the government was showing pictures. And then he goes, this is what I found on his phone. It said, can police find deleted videos on a Samsung phone? But when I asked him, did Mr. Vandenburg own an iPhone 4? Well, he said, I don't know. And I had to talk to him a little bit about that. And I said, well, I have a document here. You tell me who owned the Samsung. And who was it? Mr. Banks. Mr. Vandenburg, months before that, gave his cell phone voluntarily to the police department. Gave incorrect and important documents. The pictures. When I asked him about a picture, and I said, is that the correct time of this picture? And the reason that's important is because it says 12:06 on the picture. And it has the alleged victim in there. And he said, yeah, it's happened at 12:06. And then I showed him a different document, and it had a different time. And he goes, oh, I'm sorry about that. That's when there was a error in the system, and it caused the time to go crazy or something of that sort. Reflect bad time. And why is that important? Is because 12:06 to 1:06, the government would have you believe that there was things going on at the tin roof about the alleged victim and Mr. Vandenburg, but if the picture's at 1:06, we're just creating the timeline, trying to create an accurate timeline. So on two issues, Mr. Quinzio's iPhone 4 and the documents with the improper time because of a computer glitch or some type of virus, he changed his testimony in front of you twice when he got caught. Other than that, he wouldn't change his testimony. Captain Harville, he was a second witness called in this case, and he's the one who explained the videos, the hallway videos that showed various things. And he confirmed that, the motion detectors, some were working, some weren't. We don't have video to show you this. Sometimes they're recorded. And I understand, you go, well, what's that got to do with anything? Well, it has a lot to do with everything because they're trying to hold Mr. Vandenburg criminally responsible for 3 other co-defendants. Jaborian Tip McKenzie, Brandon Banks, and Cory Batey. So we had to trace their whereabouts. We had to trace the whereabouts of the alleged victim. And we had hours of time splits. So how could we trace them correctly and find out where they went? The state didn't ask various questions when Mr. Harville was showing you video, so I had to get up there and bring up the video. I know it was painstaking for everybody. It was painstaking for the judge. But we had to do that because it shows Mr. Vandenburg looking for an RA when he got up there. What's that? A residential assistant? Mr. Harville explained they're there to assist people and help people, and there was supposed to be someone there, but they weren't there. Mr. Vandenburg looked for someone. And the government wants to have you infer their intent that Mr. Vandenburg brought this woman home from the tin roof and served her up. That is, if you look at what went on, they went to their apartment first. Couldn't get in the apartment. Got in her car, drove her car over there. Looked for an RA. In the elevator scene, Mr. McKenzie and Mr. Banks were talking about something and laughing when Mr. Vandenburg put his arm out and didn't let them in the elevator. We know from the video that the alleged victim in this matter got up for the first time at 4:52. That's shown on the video. But before that, the time is spliced out. It's spliced. We don't know when she got up and why she got up.
Spliced, Your Honor.
Yeah, we don't know whether anything is spliced from anything.
The tape was missing because the counter goes from one time and then it jumps. That's the bottom line. Maybe I used the wrong word, maybe I used the incorrect word, but we didn't have that time space. The tape also shows, which was never asked, of Captain Harville was on the stand by the government, but it was asked by us, how many times did the alleged victim go to the room next door? 5. Why is that important? Why is that important? Because she got on the stand yesterday and said she didn't remember anything until 8 o'clock. How do you know where your friend's dorm room is? How do you knock on that door? How do you read a paper up on the door? I asked Mr. Harville, was she reading a paper on there? Yes, she was reading a paper up there. And I'm not trying to say that the stuff in the video that happened to this young woman, this 21-year-old woman, is good or she's at fault. I am not trying to say that, and don't mistake me for that. Because, again, that should not happen to anyone. What I'm trying to show you is that this case is being put together with bad evidence. If she's walking around, goes into the bathroom, leaves 5 different times, how do you know where your friend Jake Bernstein's room is? She waits out his door. Then she finally gets let in and goes in to Mr. Bernstein's room. You okay, ma'am? Then she goes into Jake Bernstein's room. Then another friend comes over, Madison Jensen, and you see them laughing, you see them smiling, you see them walking. She indicated that she was getting sicker and sicker and not feeling well. I showed you various times where she was smiling and moving around. She bent down to pick something up. She was fixing her hair. And a real interesting fact is, she had no idea, she indicates, when she left Tin Roof. She had a blank memory. If your car is driven somewhere and you say, I don't remember, I don't know where I'm at, and you have your friend come over, and then you decide to leave to go to the pancake pantry, and you leave out a side exit, not the front exit where you'd run right in your car, but the side exit. The video, she just walked right up to her car, like nothing happened. Just walks to her car. Madison Jensen gets in the passenger side, she gets in the driver's side, they sit there and then they drive off to the pancake, or they go to her apartment first. When she looked around like, how did my car get here? What the heck is it doing here? You heard nothing from the government that she contacted Mr. Vandenburg and asked, how did my car get here? Or anybody to that effect. But if my black Mercedes was in somewhere else, and I walked out and it's here, and I'm going like, huh, what's going on? I don't remember anything. Juliana Martell. You heard some testimony that was read into you today. She's not available. She indicates that she was at the Tin Roof bar with where Mr. Vandenburg was and the alleged victim was. And she says she recalled having a conversation or some type of conversation where the alleged victim said this Angie person gave her the blue drink. And it's a reflection of the facts of what, here's a square, and what the government is trying to put in the square is a circle. They're trying to make you believe that all these other facts are true. That's for you to decide. Juliana Martell, when she said, well, she told me that, and then Mr. Thurman asked, well, do you remember that for a fact? Well, that's what I said, but now I'm not sure, and we're 3 years later. Is that, but that's what I told the detective when I was investigating on this, of who gave the blue drink. The alleged victim told me this Angie person gave him the blue drink. The alleged victim says that Mr. Vandenburg gave her the blue drink. That's up for you to decide who's the credibility. And what's that have to do with anything? It goes a recount of what the facts are and who to believe and who not to believe. That's why I'm showing you these inconsistencies. And you can take them as nothing or you can take them as something, because my job, as I told you, is just to present to you what I feel is important. Detective Mayo tells the alleged victim he believes Mr. Brandon Vandenburg. He believes him. Mr. Reagan asked Mr. Mayo, would you lie to the alleged victim? He said, I would not lie to the alleged victim. And why is that important? Because what he told her, that's when they were playing his statement, Mr. Vandenburg's statement. That statement was just days after this incident. And he cried in there. You can listen to that again. You have that back there. It's a piece of evidence. He was sorry. He wished he knew what was going on. He wished he had called somebody. Mr. Mayo told the alleged victim, he told me the truth, and I believe everything that he's telling me now. He told you he didn't understand what was happening. He told you he was intoxicated. Told you he wished he called someone. He wished he stopped it. Wishing to call someone and wishing to stop it is not criminally responsible. I know some of you would like to infer that. It's just in your mind like, well, he should have called someone, he should have stopped it. That is not criminal responsibility. He also tells the alleged victim, I could tell at one point in the video he was not really happy about what happened. He also tells the alleged victim he's cooperating with us. He's doing some things to help us in our investigation. When he talks about what was happening, he goes, I'm not counting Brandon Vandenburg when I say the 3. Did you hear any evidence during this initial investigation, during when the police wanted to go after people, that any of them were helping them? No. The only one who was helping them was Mr. Brandon Vandenburg. Detective Mayo believes Brandon Vandenburg. I believe you when you say that you didn't do anything. I believe you because you've been honest. The state will probably come in and tell you police use trickery to try to get the people to talk. Oh, I trick them, I use special words, I do these kind of things. But you have to remember, he told the alleged victim, I believe everything Brandon Vandenburg told me. And what's more importantly than that, he said he would never lie to her. He told all you folks that, I would not lie to the alleged victim. And when he was talking to Mr. Vandenburg about that picture, Miss Norman says, what do they got? Just one little still shot. That's a video. That's a video from the school. Mr. Mayo says, and it looked like you were upset about something. You're upset. You started to cry almost. Is that somebody right there who wanted to get involved in that? Is that someone who would understand what was happening? Continue on Detective Mayo. And this one's important because the government is making an issue out of it. They're making an issue out of it. Brandon Vandenburg wanted to tell the alleged victim what happened. And Mr. Mayo, it's in the recorded statement. Mr. Mayo told him, no, do not tell her, do not talk with her. I will tell her, I will talk with her. So when the state tells you that what was he doing after? A couple days after when this was done, he's telling, Mr. Vandenburg says, I want to go tell her. I need to tell her. And Mr. Mayo, Detective Mayo says, no. That's recorded. You could hear him tell him that. Mr. Vandenburg voluntarily gave his cell phone. Voluntarily assisted with this investigation. Mr. Mayo believed Mr. Vandenburg when he said he was inebriated. Inebriated. The issues here have to deal with the investigation and how it was done. Mr. Mayo, Detective Mayo went up and did an investigation up to the rooms up top, the 6th floor. Mr. McKenzie's room, Mr. Banks' room, Mr. Batey's room. But I find it very funny, and not in the sense that I'm laughing, that he didn't have the CSI girl go up there and do his picture taking, gather evidence. We didn't do those. We didn't do those rooms. There's a picture of him holding a white watch as the state introduced with no glove. We heard from the CSI lady how important gloves are when you're gathering evidence so you don't contaminate things. They want us to rely on this evidence. They want us to rely that they found a box of condoms in Mr. Vandenburg's drawer, or a drawer in that room. Mr. Vandenburg's prints aren't on that. There's two others up in that room where they were. Detective Mayo did not wear gloves to investigate. Did not call the CSI lab up there. And there's identical condoms in Mr. McKenzie's drawer. And all the pictures he took were not date or time stamped. We don't know when he took those. I can't tell you when that condom box was there. I can't tell you when that condom was there. We have to rely on the government's evidence, and they want us to rely on this. Can we break for 1 second?
All right. Well, I was hoping you would finish with Detective Mayo.
Okay.
But you're not finished with him. We could go ahead and break.
I'm done.
All right. Well, we will break then.
Okay, thank you.
All right. We're going to take about an hour and 15 minutes of lunch. That's a little bit longer than usual, and that's because this is Saturday, and I don't know what's open, what's available. So you'll probably need a little more time. So we'll reconvene at 1:15 and enjoy your lunch. All right?
All rise.
We're being lunch recess until 1:15.
Joe, do you want that phone to get back to you?